Hi, everyone. Thank you for joining us on this great day to discuss the Nasdaq's rules regarding board diversity. I'm joined here by three great panelists. I'm Sheng Li, litigation counsel here at the NCLA. This is Peggy Little, senior litigation counsel at the NCLA. Over here we have John Barry, partner at Boyden Gray, who's representing one of the clients challenging the Nasdaq rules, and he's also my former boss, so great to have him here. And
glad you followed through, Sheng.
And NCLA's client is the Free Enterprise Project at the National Center for Public Policy Research, whose director has joined us, Scott Shepard. Just tell us a little bit about the Free Enterprise Project.
Well, all right. So to steal a great one, to paraphrase a great one, our politicized capitalism and shout stop.
Well said.
Well said, yes. So just to give a little background about the Nasdaq rules at issue, let's see first, what is Nasdaq precisely? It's a stock exchange that's accounts for about $20 trillion in market capitalization. It's the second largest one in the United States, next to the New York Stock Exchange. These exchanges, they predate the Exchange Act that created the Securities and Exchange Commission. Under the Exchange Act, exchanges such as Nasdaq are considered what are called self-regulatory organizations, and they create their own rules and enforce those rules against their members. But the SEC, the Securities and Exchange Commission, is authorized to supervise them and supervise them quite closely. Since the 1975 securities amendments, the supervision has become even more close, particularly with respect to rules that exchanges like Nasdaq can enact and enforce. Before enacting any rule, an exchange like Nasdaq must first propose it in publicly and solicit public comments, and then they have to go to the SEC and get the SEC's approval. Furthermore, the SEC is authorized to add to or amend any rules of an exchange like Nasdaq. So with that, against that backdrop, we can talk about the proposals here. And in December 2020, what Nasdaq did was propose two rules. The first rule, it's called the board diversity rule, and it contains a number of requirements. The most important of which I'll provide. First, there's this female requirement, and it applies to any Nasdaq-listed company with 5 or more board members must have at least one self-identified female board member. Next, we have what we're going to call the minority requirement. Those boards must also have at least one minority board member, and minority being defined as an underrepresented racial minority, Black, Hispanic, Asian, Pacific Islander, Native American, or LGBTQ+. So you can satisfy the minority requirement by having either a racial minority or someone with certain favored sexuality characteristics. And third, the board diversity rule required Nasdaq-listed companies to disclose give a statistical demographic disclosure of how many self-identified females, how many self-identified racial minorities, how many sexuality minorities they have on their board. And this also, the Nasdaq also proposed a recruitment proposal. So for companies that have trouble meeting these female or racial or sexuality quotas, Nasdaq will offer a service that they say is a network of board-ready candidates that companies can put on their boards to meet these requirements. And they don't define what board-ready is, however. So the companies can either meet these requirements, and Nasdaq says, or they have to explain why they don't meet the requirements. So if a company has a board, what they can do is, either have the female and minority representatives, and if they don't, they would have to provide a public explanation of why they can't or don't have female and underrepresented minorities on their board. And failing both requirements, presumably will get you delisted from Nasdaq, because that's what happens if you don't follow Nasdaq rules. So Nasdaq proposed this, a number of commenters, some supporting, some objecting. these guys represent, objecting commenters, submitted comments, and the SEC ultimately approved it August this year. And Peggy, I know you want to say something about the comments.
Sure. Probably the hardest part of this litigation was finding a client willing to challenge it. We found that of the comments that were filed, as far as people who were against the rule, almost 25% of those people made their comments either anonymously or under a pseudonym that we can identify, and there may be even more. That right there tells you a lot, that people are afraid of this regulation. They're afraid of being canceled in a culture that can, bring down a company through an internet cancellation campaign. Or otherwise shaming anyone who challenges these board diversity requirements. So finding Scott and his organization was a real coup for us. It's so important that organizations like his and like ours are willing to take on the regulatory organizations, which are very powerful, and say, no, this is beyond your power. And so we're most grateful to have NCPPR and the Free Enterprise Project as our client here, willing to say to the SEC, you do not have this power.
So that, Scott, do you mind discussing a little about the Free Enterprise Project's interest in this and why?
Well, sure. So in that process of standing athwart politicized capitalism, we've got to fight in two directions. And I'll tell you that I'm sure you're au fait with the fact of how many boards of directors and CEOs who were reasonably sane before Zuccotti Park have gone astonishingly hard left in ways that may be saving up all sorts of civil rights litigation for them and all sorts of backlash from various other sources. But they've done it starting in 2019 when the Business Roundtable, which is just a luncheon club for CEOs who like to go to Davos once a year. It's got no more authority than that, but they got together and said, well, we're very important people. We're very important people. We're masters of the universe. We can redefine the purpose of an American corporation. Well, they can't. Turns out that's a matter mostly of state law and largely beyond even the SEC's remit. But they got together and said, no, listen, Morgan Freeman is gone. And so shareholder primacy and capitalism built toward shareholders, we're not going to do that anymore. We're going to care about everybody. We're going to care about all the stakeholders of the corporation. Well, that sounds very noble of them. But in fact, 1 second's thought will reveal to you that you can't represent the whole of everybody because people have conflicting desires and interests. So at very best, if they were really serious about this, what they would be doing is taking polls of all their shareholders, but that's essentially everybody, so that they'd come back to where the polity is at any given election. What they're really doing is getting for themselves this master of the universe status where they can sock puppet stakeholders and then use the sock puppeted stakeholders to tell them what they want to do anyway, and then engage their own personal policy preferences in place of the long-term value of corporations. And that's an immense threat to American capitalism, because Wilsonian middle managers in the private sector are just as calling themselves experts, are just as dangerous as those in the public sector. And then, of course, the other side of our battle is the one that we're here talking about today, which is the Wilsonian self-appointed experts in the public sector are getting involved to force companies to move in this direction, and to force them. And note that there hasn't been much force from anybody yet, from the American government, for companies to go right politically. But that will change as time goes on, if all the force is coming from the left, and if these companies increasingly insert themselves into the actions of American democracy and break down American democracy. The left is going to be, or the right is going to become more and more populist. But at all event, what we have to fight now is keep the SEC at the remit it had when the Securities Exchange Act was created. And this is the first real effort to get past the provisions of that act, which, and I defer to you, Sheng, but essentially their job is to require certain disclosures, certain limited disclosures from corporations so that smaller shareholders can be knowledgeable and not bamboozled.
About fair and honest dealings in security exchanges, which I don't see, race or gender being really implicated in that.
Right.
Right. So how does the Free Enterprise Project kind of get involved in corporate corporate governance?
Well, some of the ways that we get involved are to file shareholder resolutions, shareholder proposals, and we do that from the right. And we're just about the only organization so far. That's going to change, but so far, organization from the right that files those shareholder proposals. And there's a coalition, the As You Sow coalition, of about 120 organizations on the left who have been doing this for decades. I mean, when I was in law school 300,000 years ago, the notion was this was a beginning thing that professors were starting to pay attention to. By the time we got involved, there were about 400 a year being submitted from this broad coalition. And that, along with the Occupy Wall Street, Eat the Rich campaigns of 10 and 11 years ago, were real catalysts for corporations to move left. So that's where our involvement, that's where we hit the road. Great. In this suit.
And John, I know Peggy was mentioning how difficult it is to put your name out there. And I understand your client is a collection of anonymous individuals who's challenging this rule. Can you talk a little about their interest and your involvement here?
So I'll start with our anonymous member, which is Mr. Edward Bloom, who's the head of the Alliance for Fair Board Recruitment, and has long been involved with challenges to unconstitutional preferences on the basis of race or ethnicity. So think the Harvard affirmative action case that's with the Supreme Court right now, as well as historically the UT Austin affirmative action case. He is. We recently submitted an affidavit of his speaking to the death threats and other sort of vile anti-Semitic slurs and other things he's been repeatedly exposed to over the course of his work in that obviously controversial area. Interestingly, controversial part goes to the merits on the First Amendment piece. But I think in recognition of that level of controversy and the fact that sort of the counter to stand athwart the sort of the diversity machine really invites a lot of hatred. We submitted and we're pleased that everyone agreed, including Nasdaq and the SEC, as well as NCPPR through NCLA, to actually a protective order in this case to allow anonymous submission of affidavits. We have a coalition of shareholders, of current Nasdaq listed company board directors, multiple people who I think, to use Nasdaq's words, are board ready, but who are not being put on a level playing field in terms of competing for board director positions. We have one of our sitting director members does self-identify as one of the minority statuses that's privileged, but does not wish to have stigma associated with being perceived as a diversity hire. And then last and certainly not least, we have our member Company Doe, which is a Nasdaq listed company that is participating anonymously under the auspices of Fifth Circuit precedent that permits just that. So it's a diverse coalition. I'm confident that between the sort of the injuries asserted by our respective clients, that the challenges being presented are really going to have good standing in litigation.
So, John, a lot of libertarian and folks on the right will say, private organizations should be free to determine their own membership, determine their own rules, be that disclosure rules, explanation rules, even race quotas. What's wrong with Nasdaq trying to do this? Why is Nasdaq claims to be a private organization? Is there how do you respond to that?
Yeah. So it's important to recognize as so Nasdaq is a stock exchange, which is a species of SRO, self-regulatory organization. we could talk in terms of economic theory, political economic theory. These are maybe not natural monopolies, but natural oligopolies, and that you could draw an analogy with utilities, for example, where even if these are private companies, there still is greater propriety for public regulation. But what's really relevant here, so as an initial matter, we're in the Fifth Circuit. The Fifth Circuit has stated directly that when an SRO, in that case it was the American Stock Exchange, is sort of acting in intimate involvement with a government agency, at least those acts are going to be subject to constitutional scrutiny. But even if Nasdaq is not directly bound by that, keep in mind that it's got an ongoing federal law duty to enforce and police compliance with its own rules. Nasdaq is on the hook vis-a-vis the SEC if it fails to enforce these very mandates, assuming they've taken effect. And you could also, we talk about the analogies with Sheng Li v. Kramer, which prohibits state enforcement of private racial discrimination.
Right. And I think it's important to understand NASDAQ, even though it has repeatedly professed to be private, it has a very intimate relationship with the SEC, particularly since the 1975 amendments put NASDAQ's rulemaking power basically completely within the SEC's purview, because the SEC can disapprove any rule, can add rules if it wants to, can change rules. So the SEC can actually come in and say, well, you say you need one female, we're going to change it to 2 female. They can do that, and under Supreme Court precedent, it's not the label that matters, whether something is private or government for the purpose of Constitution. For example, Amtrak, the statute creating Amtrak said Amtrak is a private non-government entity, and yet the Supreme Court has said that Amtrak has to follow the First Amendment and can't ban billboards that it doesn't like. And so, the First Amendment applies to Amtrak, and arguably it might also apply to the SEC. So, what are there any First Amendment problems you see with the diversity rules at issue here?
Well, I would describe the rule that particularly offends the First Amendment as the SEC's approved rule saying to private companies, you fill your board as we say you should, or you've got some splaining to do. And that is offensive to the First Amendment of the Constitution. There are numerous cases that hold that. West Virginia versus Barnett is probably the most venerable, which says if there is one fixed star in the constitutional universe, it is that no public official, no matter how high or petty, can prescribe to a private company or person what they must say or what they must believe. And there are other cases. There's a case out of the DC Circuit where the court held that the SEC could not force companies to disclose whether or not their minerals were conflict-free. And it was a very interesting decision in which they said that this was a sort of forced self-condemnation. The company would have to say, we deal in dirty metals. And here it's, that we're just not up to the task of diversifying our board. And this is terribly important because the qualities that were selected by this rule have nothing to do with the efficient and effective operation of capital markets. A person's sexuality has nothing to do with that. In fact, I think someday we'll come to understand that you check your sexuality at the door, and that does not bear upon what you do at work. And that precisely because it ought to be illegal to ask people about their sexuality before you hire them, it should be similarly wrongful to be awarding these plum positions, and they are plum positions, to people on the basis of their sexuality, which has absolutely nothing to do with operating a company effectively. The law in this area is quite clear under state law. The Delaware Supreme Court says it best, I think, that the sole object of corporate governance should be maximization of value for shareholders, and that's it.
And when I was looking at especially the disclosure of sexuality requirement under this rule, I was thinking under maybe less enlightened times, and maybe the 70s and 80s, when folks weren't so tolerant of different behaviors, that if this similar requirement were passed, it would be seen as clearly a kind of discriminatory or a bigoted attempt to force companies to disclose that they're secretly hiding gay or lesbian board members, and that would have been publicly condemned, surely, especially by today's standard. And yet we see the SEC and Nasdaq championing it.
And we could get into the details later, but this is very difficult to even imagine how it gets policed, because these disclosures are supposed to be made in the aggregate. So they would say there are one or more seats, but you don't actually personally identify the person or persons who fulfill these requirements. So how do you police it? How are you sure the companies are even complying with this? All of those defects are just testimony to what a wacky idea this is.
Well, and Peggy, add the fact that the LGBT plus category also includes the term queer community, which is not, and I'm not cutting on anybody, but a self-identified member of the queer community, I'm reliably informed by my teenage nieces, means absolutely anybody who wants to declare it that day.
Right.
I mean, so it's not only it's an inherently undefinable or uncategorizable term, and since they're all self-defined, they all become inherently uncategorizable. So there's no way to enforce it. There's no way to make any sense out of it. But it is the opening wedge to go from 1 to 2 to 6 to half to.
Sure.
And it's a way of it really puts pressure on this idea that these are somehow standardized disclosures that are being made, as if you can capture anything about a person's life experience, like your heritage, your sexuality, whatever it is, by really down to the level of a commodity. You're just checking a box. It's absurd. It
is absurd. And the other thing I was noting, I saw just recently that Boeing was saying that it is going to be, in the future, it's going to be sure that it has someone who is very knowledgeable about airline safety on its board in the future. That's a relevant consideration. That is what a corporation like Boeing should be looking for. None of what we've been discussing today has any bearing on that. And so a board's ability, when it has a limited number of seats, to fill its positions with what it should be filling it with, which in the case of Boeing would be people familiar with airline safety, is going to be impaired by meeting these other irrelevant and untailored categories. The other thing that comes out when you read through the comments is a number of people were advocating for, say, veteran status or the disabled status. My favorite commentator actually said ex-felon status. That was a joking comment, but the point being, these are just totally arbitrary characteristics, and they're ill-suited and utterly irrelevant to what a board should be doing.
So Nasdaq, however, didn't think these characteristics were irrelevant. In fact, Nasdaq's position, which SEC actually backed away from a little bit, is that by having people of different races and genders and sexuality on boards, you will improve corporate performance and reduce fraud, because it actually reduces by the confluence of this sort of diversity will somehow reduce groupthink. Scott, what do you think of that?
We've looked into this quite a lot, and it's high tone nonsense, because there are a couple of there's something from Denmark from 10 years ago that looked at whether boards with more women on them did better than boards, but there were no control variables. So they haven't controlled. It's possible that more diverse boards are more valuable, but you have to control for the type of diversity involved. If racial and sexual and sex orientation diversity suggests that there's a wider viewpoint diversity on the board, then that might be valuable, but that study's never been done. And there's been no controls for whether Now, say that in the last 10 years, tech, and I'm not certain this is true, but it's tech, right? So tech has done so much better than, say, petroleum. If you compare those two industries and say, well, this one has more women in it and this one has fewer women on the boards, then you're gonna get a technical result that, oh, the boards with more women have done much better in the last 10 years, but it doesn't mean anything. It's just, well, contra Dr. Fauci, there are rules before you can declare something science, and these studies are certainly not science.
So even if there were some sort of benefit, it seems if Nasdaq were in fact, governed by the Constitution, they would also be, in addition to the First Amendment, be subject to the equal protection restrictions. And so, John, do you want to? I know your client is very involved in that aspect.
Yeah, absolutely. So, right, where the sort of the kind of the materiality or the issue of the relationship between diversity and corporate performance, as just discussed, the evidence just isn't there, and even the SEC admits it. That's relevant to the question of whether there's substantial evidence under the Exchange Act to authorize this as a statutory. It doesn't go to the constitutional question, which on this issue is very straightforward. Corporate money making, like increased corporate money making, is never a compelling interest to justify racial discrimination. That proposition has a very fraught history in this country, and for very good reasons. It has never been tolerated for as long as we've had kind of live and robust equal protection jurisprudence to allow that. So you have, there's the money making corporate profitability aspect, for which the evidence is itself problematic as a matter of law. That does not cut it. Nasdaq has likewise asserted, SEC has echoed this, that there's sort of popular investor demand that might be some kind of interest. As a factual matter, once you dig into it a little bit, it's really just relatively narrow cadres of institutional investors and their surrogates who are actually rattling the SEC's cage about this. But again, constitutional right to equal treatment, it gets to outweigh sort of whatever popular demand might be, even if it is a real thing. And factually, it's just not. Say nothing of narrow tailoring.
Nasdaq and the SEC, however, they say this is not really a quota because you can explain yourself out of it. So does that change the equal protection calculus at all?
It really doesn't. The courts have been pretty clear from the Supreme Court City of Jacksonville case. So I'll mention that one. So City of Jacksonville had a 10% set aside for both minority-owned businesses and women-owned businesses, and some disappointed contractors challenged it on constitutional grounds. And the Supreme Court held that there was a cognizable injury, in fact, arising from that scheme, at least as alleged at that early stage of litigation, even though it was not actually a hard quota. It was a 10% set aside, but the City of Jacksonville they were obligated to make, I forget if it was good efforts or best efforts, but if they fell short, that was okay. It was a goal, it was an aspiration. And when you drill down into the Fifth Circuit case law, as well as the Ninth Circuit case law relevant for California litigation on this similar issue, you have the court saying the Constitution, sort of constitutional protection concerns, whether through the Fifth Amendment against the federal government, the 14th Amendment against state and local action, those concerns are triggered when you have racial classifications, when you have laws or state acts that not only mandate racial discrimination, but merely authorize or encourage. That's a comparatively low bar, and this sort of aspirational framing absolutely clears that bar.
And speaking a little about NCLA's own interest in this, So we've in this last year or two seen a lot of instances of administrative agencies stepping way outside of their lane, and this seems to be the latest step of that. Earlier, about a year ago, the Trump administration's Centers for Disease Control enacted a nationwide eviction moratorium on the backs of a statute that concerns fumigation and extermination. I made it all the way to the Supreme Court, and the Supreme Court said this has nothing to do. The regulation that you enacted about eviction have nothing to do with the statute that you claim authorized this. And currently, NCLA is involved, and I think your firm as well, in challenging workplace safety regulations, quote unquote, enacted by OSHA that which is tasked by Congress to regulate safe workplaces. And instead, it has enacted regulation that requires 100 million Americans to get vaccinations. So say, people can disagree about the merits of vaccinations, but we can kind of all agree that vaccinating the entire country kind of falls outside of what OSHA was designed to do. And here, this seems to be, again, the SEC and through an SRO, Nasdaq seems to be stepping out of its lane. It's the Exchange Act was created to ensure fair and honest, transparent securities transactions, and in that regard, you have to disclose if a company's publicly traded. You got to disclose your earnings statements and that sort of thing that investors might actually care about. But here they're doing something else. They're social engineering. They're setting race, gender, sexuality quotas. People can disagree about whether those quotas are good or bad, but it certainly has nothing to do, I think, with securities transactions. And we think we at NCLA think that's a problem, primarily because it's an agency exercising power that an agency has not been given. And
well, they also have a bunch more in the barrel.
Yes.
If you've heard of ESG investing, environmental, social, and governance investing, they've got a proposal waiting. It hasn't been promulgated yet for comments, but it's, I guess I'm told it's ready, that will require companies to disclose all sorts of things that fit, and given the tenor of the majority of this current SEC, this won't be surprising, that fit left-wing political agendas. And so they're actively, they speak in the high-toned words of environmental, social, and governance agendas, but it will politicize the SEC, and if it survives, then almost by definition, when the other side has the majority of the SEC, they're going to revoke those rules, and then we're going to have intensely, permanently politicized corporations that, just without considering anything else at all, cannot possibly be as effective and efficient at doing their jobs, raising money for not only for their owners, but for the American people and for the world, than they were before they had to bow to political masters in changing, every 8 years, the rules change. That you just can't build an economy or keep our current economy that way. So you all are saving us. You're both saving us from the beginning out of the wedge.
How does a rule like ESG or in this case race quotas and gender quotas, how does that interact with, say, a corporate director's duty, fiduciary duty to his or her shareholders?
Well, I mean, that's part of what we have to fight against, because under Delaware law, as Peggy was just pointing out, the ultimate duty is to the shareholders and the long-term value of the company. Those mean more or less the same thing, but in very specific ways. The state of Delaware has something called a public benefit corporation, that if you want to dedicate yourself, even as a business, to some charitable values or some social values, you can do that. But no companies want to do that. And so where the fit is that this all fits together to politicize, because in the ESG spectrum, mandatory quotas for favored minority groups is part of the S. So this is just one slice of that broader.
And so for the audience, the other parts of the ESG, you just explained that.
Oh, sure, yeah. Environmental, social, and governance. So environmental is 90% climate change, and it's always the breathy climate catastrophist, UNPC program. And social is any woke left of center thing you can imagine. And after woke spun up in, was it 2019 or 20, they've gotten much more aggressive in the things that they're demanding, whether through shareholder resolutions or just as general activists. And the left is much better at activism than we are in the right. So, a lot of these corporations just get bullied.
I think nobody's paying enough attention to the fact that it actually is a deeply offensive concept to think that corporations would be better governed by people of certain sexual orientations or racial orientations. There's something that is deeply racist and deeply discriminatory about the very notion that is being promoted here. But I think what's really going on with ESG and also with the board diversity is that the current party in power is capturing things of value, and board directorships are coveted. I mean, these are what people want at the end of their career. They pay lavishly for very little work. And so they're appropriating those private assets and forcing the corporations to speak in the voice of the current political majority. That's a deeply frightening notion. The fact that we now live in a country where the government can tell a board what its directors should say and look like and believe and attest to. I don't want to live in that country, and I don't think most people who want to get into this country and make a good living and a future for themselves want to live in a country where the government dictates what a corporation says or believes.
Speaking of these board positions being quite coveted and remunerative, part of this rule, and I think it's been under discussed in the press, and it hasn't even been addressed that much by the comments, it's this board recruitment service that the Nasdaq will give any listed company that's having trouble meeting the gender and race and sexuality requirements, and I think quote unquote a access to a network of board ready candidates. What kind of trouble do you see that could happen?
I mean, aside from it, if we just broadly say half of the country really likes racial, sexual, and sexual oriented quotas, and the other half of the country really likes paying attention to individual merit, and Nasdaq has been the instigator of one side's views, then we can just fairly easily imagine that list is going to be made up of people who agree with those views. So it'll be another step of politicization in this whole process.
Oh, yeah, and to the extent viewpoint diversity, as opposed to skin color diversity, is the driver of effective corporate performance, I would imagine that you reduce viewpoint diversity, you fill all board rooms with these board-ready candidates.
Oh yeah, and you can really put left-wing CEOs on the spot by, well, what about viewpoint diversity? We asked, not I, but my boss asked Apple lead
Tim Cook.
Asked Tim Cook a couple of years ago. Well, we're getting reports, and they're news reports, that you're getting rid of people or stopping conversations if they come from the right, but allowing 1,000 flowers to bloom if they come from the left. And he absolutely insisted that was nonsense and anybody could come to him personally. And then, the march continued to the left. So,
well, so Nasdaq's contention, both the Alliance and the Center contesting Nasdaq's contention that viewpoint diversity and all kinds of this sort of required types of diversity will improve board performance and improve viewpoint diversity. How and SEC has walked back a little from that. John, do you want to start talk about how this is relevant from litigation perspective?
Oh yeah, it's highly relevant because the SEC has taken in our view, has taken off the table the need to dispute in court this empirical question about whether diversity, and specifically diversity mandates, improve corporate performance. They're not relying on it directly. There's still, and I think this is going to create some interesting challenges for the SEC and Nasdaq and litigation. They're still kind of relying on it in an equivocal fashion in the background by saying that there's investors value this implicitly. The only purpose for which it would be cognizable under the Exchange Act would be for corporate performance. So they're going to be on the horns of a dilemma there.
So my understanding is Nasdaq said, hey, we're gonna put these diversity quotas out there. We think it's going to improve corporate performance, and that's why we're doing it. The center and the alliance comment and say, hey, the research doesn't back up that conclusion. The SEC looked at it and said, we agree that at best this is mixed evidence, this is inconclusive, but we're going to enact the rules and approve anyway, and not based on the belief that, not based on evidence that this will improve performance, but rather based on the fact that there's some set of investors out there who want disclosure, and implicitly those investors' belief is an indicator that this will improve the performance. Is that, am I characterizing that correctly?
It's kind of wrestling a fog, right?
Right. It's kind of like a
frog.
Yeah.
Oh my God, I deal with the frog.
It seemed they were being kind of wily there in the approval order in saying, well, on one hand, there's benefit to this. On the other, we're conceding the evidence for the benefit. It's inconclusive, and therefore you can't challenge us on it.
That's right. I mean, the ultimate goal cognizable under the Exchange Act is helping people make securities transactions with an eye towards sort of improving shareholder value, shareholder wealth, and the like, and just improving the functionality of our national market. They've disclaimed that these mandates advance that ultimate goal. And they've said they've used words over and over again, like mixed evidence, inconclusive evidence, but then point to the demand by, as we put it, kind of a subset of the money class that operates NASDAQ and operates these companies. This kind of narrow population of people, depending on how you count, maybe it's 50,000 people in America, and maybe that's even that's being generous, perhaps. But that's not mere consumer curiosity. There's a great Kavanaugh opinion from the DC Circuit talking about this. Mere curiosity is not grounds for disclosure, and so I think that kind of sounds in both the kind of failure to satisfy the statutory predicates under the Exchange Act, as well as teeing up, what I think is a very straightforward constitutional protection case.
There's also zero evidence in any of the materials that the SEC or that NASDAQ has put forth that somehow corporations are unable to respond to their shareholder interests. There's been no finding that if there is in fact a groundswell of people interested in having such representation, that the normal form of corporate governance is not sufficient to meet that demand. I mean, there might be some industries in which shareholder interests could gin up board membership that would track this, but there's a complete absence of any evidence whatsoever that the existing form of corporate governance fails to meet shareholder demand. And so they're operating on a base of no evidence. And in fact, I would say the fact that they are strong-arming the government to force this on corporations suggests that corporations would not do it on their own. So you have a prevailing political party that is determining outcomes, forcing viewpoints, forcing corporations to express views or hire people on certain irrelevant characteristics, or explain why they're not doing so. That's very totalitarian, and I think that should be said openly and without fear.
And in this regard, corporations have been, without any government mandate, becoming more and more diverse along these very lines over the past year. In fact, a report came out just a few months ago indicating we're at peak gender diversity among corporate boards and peak racial diversity. And in fact, if a it's regarding the disclosure requirements of this rule, it's not, the gender and race of corporate board members tend not to be secret because their pictures are on the websites, and maybe not they're self-identified.
Well, that's a whole other
thing that we think it's
complication.
Certainly private and not and not anyone's business. And the third part of the disclosure requirements, the sexuality, again, seems to be quite a private matter that bears no relationship to corporate performance, and it's really nobody's business.
Absolutely. I mean, think about it. I think anyone in this room would be offended if they were asked about the sexuality in a job interview, and yet somehow
isn't that illegal?
It should
Isn't
be.
that super illegal?
and now it's de rigueur in a very odd and unverifiable way.
Yeah, Congress passed Title VII to prohibit this sort of discrimination.
Yep.
When it comes to hiring employees. Now, most corporate board members are not under the definition of Title VII considered employees, so that doesn't apply to them. At least that's SEC's defense. But certainly,
although in the race context, Section 1981
right, that
does actually forbid race discrimination even in private contracting.
Right.
Yeah. So Congress has spoken pretty clearly that race discrimination of this sort is prohibited, and certainly Congress nothing in the Exchange Act suggests that Congress has authorized SEC or any SRO, any exchange it supervises, to discriminate on the basis of race or gender or sexuality.
Yeah, if I may, to piggyback off of Peggy's point about the lack of history here. So this is something that my client and its affiliate organization, Project Fair Representation, deals with a lot, is one of the sort of the narrow categories, very narrow circumstances in which sort of race-conscious government programming is permitted under Supreme Court doctrine is circumstances of remedying past discrimination by a government entity. That this administration, in a variety of ways, is really trying to stretch that definition in a variety of areas. But here, in this case, that's not that one place where the courts have sometimes blessed race-conscious mandates or programs. There's nothing. There's just there's nothing out there at all.
The fact that it's not in the statute. These race mandates is not in the Exchange Act.
I don't think
Securities Exchange Act and NESRO in the history of the Exchange Act since 1934 have never tried anything like this. Have never said we favor this race or we favor this gender. And it's lo and behold, they suddenly discover some kind of power to do so today. And I think under the Supreme Court precedents, the courts should look askance at such kind of discovery of a newly heralded regulatory power to essentially regarding the demographic composition of not every American company. I guess Nasdaq is about half the American companies, but if Nasdaq has this power, the New York Stock Exchange would also have this power, and so that's almost every public corporation in America. And if they have that power, then it doesn't have to come from an exchange. It can come from the SEC itself, because the SEC has the power to add rules or amend them. So the SEC can come down and say, now all publicly traded companies in America, we have this demographic or that demographic characteristics should be favored. And I think that's, if Congress intended the SEC to have that power, I think it's quite broad and quite controversial, and they would have said something. And yet the blanket slate.
If it were possible to invest in legal doctrines, I would buy the major questions doctrine, because that's something that's going to get a major workout in cases like this and other places where you have agencies getting out of their statutory lanes. SEC is doing this. Department of Labor, where Sheng and I worked, is doing this. banking regulators are doing this in very similar moves as we're seeing here. Diversity or climate investments bear on the safety and soundness of banks. It's all part of the same initiative.
It's a very similar pattern, right?
Yeah.
The Supreme Court said Congress doesn't hide elephants in mouse holes.
Yep.
And that seems to be what's happening here. It's the SEC has seized upon a line of text in the Exchange Act that says, oh, an SRO can enact a rule that protects investors and serves the public interest. And, and through one leap of logic to another, you can protect investors to raise quotas by saying, well, some investors,
aggressive,
right? Some investors want disclosure of diversity. Diversity along race may improve corporate performance. There's mixed evidence on this, and therefore it serves investor interests. And that's sort of the leap of logic that they're making. And I think the courts are going to require a little more explicit statement of authority to get there.
Well, because if that logic is permitted, then it's Marshall turning the necessary and proper clause into an invalidation of the whole system of the Constitution, right? So anything's necessary or proper. Anything, if that line of reasoning is allowed, then in the future the SEC can mandate anything.
Right. I think it's important to focus on the vacuousness of this. There's nothing, you can't make that logical leap. You can't make it empirically. The SEC actually seems to admit that. And also this issue about the list of board-ready candidates. There's nothing at all in the proposed regulations. It talks about who sets up this list. How do you get on it? Well, when you have that vacuum, we all know what fills a vacuum. It's going to be political cronyism that is going to have these board-ready candidates. So there's no rules. It's a sheer arrogation of raw power, and surely that's something a court has to be very concerned about, whether this is going to somehow institutionalize powers of cronyism that were unthinkable at any time Congress actually voted on a statute that empowering the SEC to do anything.
Well, there's nothing in the rules about what board ready means and what what process Nasdaq might use to put people in this list and offer to companies. Then what did the SEC review when it reviewed Nasdaq's proposal?
Nothing.
Right. So what is that? Is that a problem?
It's a vacuum, and surely there's authority out there that when an agency is acting on a non-record, an absence of evidence, it surely is at the weakest defense of its assertion of power.
And I think there's a then Judge Garland opinion from a few years ago on this issue that said, hey, the SEC can't just be rubber stamping the rules that SROs are proposing. It has to do its own independent analysis and do its own fact finding and determinations, and can't simply accept what the SRO is giving it. And now, with respect to some of the board diversity requirements, the SEC seems to have done some of that. In that, it's rejected, for instance, Nasdaq's contention that that race diversity, for example, improves board performance and instead concludes inconclusive evidence. But with respect to, I think, this board ready list of candidates, there's nothing. If there's nothing that as Nasdaq, no substance in Nasdaq's proposal, the SEC could not possibly have. I just can't imagine what they could have done to analyze, to make their own, independent reason analysis.
Sure seems to be in tension with what Judge Garland said. And I would add, like as a constitutional matter, at least when you're talking about the SRO in a standard setting capacity, if the SEC is giving that blank check to Nasdaq, you've got a potential private delegation issue as well. I don't know if NCLA has any views.
Well, sure. I mean, the private delegation issue, because Nasdaq contends that it's a private entity, so all this is okay. But as we know, the Supreme Court said a delegation of regulatory power to a private organization is the most obnoxious or noxious form of delegation. I forget the exact. There
was something noxious.
Yeah.
Noxious.
Let's stick with noxious.
Yeah.
It works.
And so if Nasdaq is correct, and as it insists, it's completely private. But but it's it's exercising delegated congressional authority, right, in enforcing rules, in delisting companies, in enforcing, if it tries to delist a company, for instance, that doesn't that refuses to explain why it doesn't have enough LGBTQ board members, then at Nasdaq we exercising congressionally delegated power as a private entity, which presents due process and private delegation problems. So that again, it's one reason we think it probably isn't a purely private entity, and the court should avoid that result and instead treat it as a public one for at least the purpose of constitutional scrutiny. We're running against time. Does anyone have any kind of closing? I'll let folks have some closing remarks here.
So just
before we move to Q&A.
One thing I wanted to note is because it might not get out there. One of the many constitutional issues here also goes to the question of narrow tailoring. And I'll point out a theme you're going to see more and more of, which is the Nasdaq rule here is under-inclusive for a couple of reasons, but one of which is it doesn't apply the race and the racial or sexual minority mandate does not apply to foreign issuers. These are foreign companies who list on Nasdaq. They can instead satisfy simply by having a second woman as a board director. This, despite the fact that lots of foreign issuers are in countries that have no laws analogous in any serious way analogous to, say, Title VII or Section 1981. I might mention like one very large country that has a couple issues with, I don't know, genocide. And we put this in our brief that PRC based, People's Republic of China based issuers we doubt there are many non-Han Chinese board directors or any Uyghurs on any of these Chinese boards of directors, and yet they're left off the hook. That's, as a policy matter, that's crazy. And as a constitutional matter, it's just one more nail in the coffin on this thing.
And I think you've just lifted the curtain and shown the hypocrisy.
It's real ugly.
Yes.
All right, let's move on to questions and answers. Do we have some?
We do.
Oh,
we do.
we-
So Emily in the chat wants to know just exactly how does this representation requirement works. What if a company could show that all of its investors are in fact white men? Would that who's being represented and for what? She's sort of asking I think a really interesting question about who's being represented and to what end.
So this rule, it's not, it's purportedly to serve investor interests, but it's not to serve the actual shareholders of any particular company. The racial or gender or sexuality composition of the shareholders is irrelevant for compliance with this rule. So even if only white men bought shares of this company, I might have questions about what the company does, but
Rogaine.
if that's the case, all right. But even if that's the case, the company will still have to have at least one female director, at least one underrepresented minority director, or explain. And maybe it can explain. And maybe the explanation is we have all our shareholders are white men. But the explanation requirement I want to add is it's styled as an explanation requirement, but as Peggy alluded to before, it's
compelled speech.
It's more of it's a forced apology, really. To say, shame on me for not meeting this requirement that's supposed, that's
An anonymous
good
member of the chat actually asked earlier if the explanation requirement was akin to a kind of struggle session where you have to get up and explain how you've fallen short of the Maoist ideal.
It's exactly that, along with the fact that we have the crowd, because when you had the struggle, then all the kids would come and beat you on the head and stuff. Well, the current version of that is that if a company has to explain, we thought we'd follow the Constitution instead of having quotas, then all the woke kids come and try to cancel everyone involved. So they've got all the parts of that ready to go.
So Braden jumps in here and wants to know, look, if there's no demonstrated value to diversity, board diversity, gender minority, for corporate performance, then what could possibly be the value of disclosing a thing which has not been shown to be relevant? So Braden's a little confused about that. If that's not valuable, if it's not demonstrated, then what could possibly be the value of the disclosure?
Political. And Braden's right to be confused about that, because just as Scott has so ably shown, that opens the corporation up to cancellation, group political dynamics that have absolutely, not only is it irrelevant to corporate performance, it could take down a corporation that is otherwise providing a valuable service or goods to its investors and to the people of the United States. And yet, if it does not comport with a certain government view of who should be running you, you could get canceled. That's a terrible consequence.
Yeah. Great. So Sigmund, oh boy, Sigmund knocked it out of the park. Let me just, and then we can go to.
All right, we'll go to audience after one more from.
Yeah. So Sigmund wants to know if Nasdaq is going to post a bond, just in case any of their recommended board members turn out to be embezzlers or corporate malfeasers.
Yeah, there's nothing, again, because the rule is completely vacuous on anything. There's this board recruitment rule has nothing behind it. Just as we will give you a board ready, there's no satisfaction guaranteed provision.
Yeah. And as I recall, you don't have to use their company. They offer you the sweet chance to use it for free for 2 years. But after that, it's not clear whether you'd even have to pay NASDAQ to get its list, right? And so it's the mob style of regulation. You don't have to use our list, but we got all the kids ready to cancel you. And
Right.
so,
That's a nice company you got there.
that's exactly
Shame
right.
we're about to destroy it.
Yeah.
I think we got some audience questions before. Mark?
Do we have a microphone or?
No, just
Okay.
Shout.
So, well, I thought you were going to say that it's like, well, your first one's free. And then,
That's right. There we go. Yes.
After that.
This baggie of candidates is free. The next one. That's
Hey,
right.
They value their services at $10,000 a year.
There you go.
No evidence.
So I have a question for Peggy and a question for Jonathan. My question for Peggy is, what happens to democracy? I mean, board positions at companies are voted on by shareholders. These are supposed to be democratically elected positions. So you have a federal government agency coming in and taking away the democratic rights of shareholders and substituting an anti-democratic goal or aspiration of the federal government in place of the democratic voice of shareholders. That seems problematic to me. And then my question for Jonathan is, you mentioned the major questions doctrine, which I would also like to buy some shares in because I agree with your analysis. But I do wonder, why not just straight out non-delegation doctrine? I mean, it seems to me that if the SEC is trying to read the statute, just the words
Public interest and protecting investors.
To suffice, that's not nearly enough even under existing non-delegation doctrine. That doesn't strike me as enough of a principle to be specifying to allow SEC to do this kind of regulation. So.
Well, to answer your question, that's why I focused on the fact that there's absolutely nothing in the records, the comments, the proposals that talks about a failure of corporate governance that would require some sort of government intervention. In fact, as Sheng indicated earlier, boards are getting more diverse. More and more females are having those positions of power. It seems to be a solution in search of a problem. But I think in terms of how we litigate this case and how we talk to the American public about this case, we should openly talk about what a seizure this is. This is government seizure of corporate democratic governance to further the current administration's ends. If you flip the politics on that, that becomes the nightmare of all nightmares ever to anyone, that say a Trump administration could start to dictate who is on the board of corporations and they need to comport with Trumpian ideals. I mean, that would
quota.
Exactly. I mean, man, oh man, the outcry, rightly so, would be deafening. And we need to convey this message to the American people that the greatest engine of wealth creation ever in the history of the world is the corporation and exchanges of value through corporate governance, and for the government to seize that for its own political ends is profoundly undemocratic, profoundly contrary to our founding principles, and must be resisted.
Even if Hunter Biden is board ready?
Yes.
Well, he will be the art director.
Mark, to your question, yeah, I think that there's a bringing certain non-delegation issues in this specific context can get potentially a little bit wrinkly, because we've got the SEC approving a private proposal. I think that, I think that is present here potentially, maybe even more squarely present in the upcoming SEC disclosure rulemakings on either climate or diversity, human capital, maybe on some of those. But I look at major questions and non-delegation as traveling together. So major questions lines out the realms in which it's unlikely, or courts are not going to conclude, that there has been a delegation by Congress to an executive agency. So that's kind of layer one. And if a court concludes, well, we have to read the statute as there having been this delegation, which I don't think is ultimately this case, because precisely because of major questions, then the court has to decide, is that delegation constitutional? And yeah, I don't see how it could be, but I don't know if we'll get there in this particular case.
I'm going to pour a little cold water on this. All this stuff started in the colleges and even state universities, all kinds of quota systems, all kinds of things that were not part of their charters or part of the law or anything about it. But diversity and inclusion, all that stuff, nobody has to prove anything in colleges for this. And right now, the Harvard case, they lost, right? They lost. That's going up further, but they lost. Could it be that this unprovable assertion about diversity and inclusion is so ingrained within the subset of the elite that it doesn't matter what you argue? They're just going to say, oh, it's just like the universities. We allowed it there. We're going to allow it here, 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 and it'll spread through every institution.
So I'm just speaking for myself. I don't think it's the ability, so the law is I do believe that the law is a teacher, whether it is a teacher for particular subsets of elites, maybe not. I do think on the margins it can have an effect. I think more concretely in a case like this, or in the cases that Mr. Bloom's Project on Fair Representation is working with in the Harvard case, UNC, and so on. I do think the law can meaningfully change incentives in ways that can have cultural consequences. I don't hold any illusions that even if we win big in this case, or Students for Fair Admissions wins big ultimately with Harvard or UNC, that's going to kind of change the culture overnight. But I do think it plays. I do think law and culture do inform one another. I think that's why I view this work as worth doing.
Well, just two quick thoughts. One is that education's always different when with regard to race in particular, because you've got to go all the way back to Mecklenburg County and, the desegregation in the South. And then Bakke was specific about grad schools, and Justice O'Connor promised us in 2003 in Grutter that we have a 25-year clock. So we're almost done with any discrimination, even in the schools. But then just to pour some warm water back in, the 13-point shift in two what were fairly blue states that we saw last month suggests to me that people are about done with this once they've realized how bad it's gotten. And then so if we can just stop them in the corporations, we still have to fight the countermarch through the institutions, but we'll all be dead before that gets done.
That was warm water?
Felt kind of cool to me.
Take the long view.
So there is a question, maybe one last question.
One last,
before we
sure,
wrap
let's do
up. And it's another, this is a lively chat, and they're throwing out hypotheticals, and someone wants to know, does a board have to, does a company have to explain that it has a 100% female board or a 100% LGBTQ board? Would they have to? That's fine. No
That's,
problem.
I think that's 100. If it's 100% female, they would still have to have an underrepresented minority. So if one of those females were Black or Hispanic or Asian or LGBTQ, then that would be fine. But yeah,
But if it was 100% diverse, then along those
right. There's no
axes, that would be
requirement to have white straight men on boards. No explanation required if you fail to have one of those.
And you can have this this ironic circumstance where you could have members of a specific racial minority with diversity on the basis of sex, so it's fully compliant with this. But you could have 100% homogeneity along these demographic categories on a board, and that would be completely fine. No explanation elicited. None of that disclosure happening.
I suspect that'll help you in your briefing.
I suspect we may have.
So thank you, everybody. And that concludes our lunch and law for today.
Thank you.